On January 11, 2026, the Massachusetts Appeals Court heard oral arguments in Commonwealth v. Del Valle Rodriguez, a case challenging the defendant's kidnapping conviction. Mr. Rodriguez was convicted along with co-defendants after an incident where 3 victims were attacked when their vehicle became stuck in mud. The defense argues that while assault charges were properly sustained, the kidnapping conviction should be overturned because there was no intent to confine the victims. Their inability to leave was caused by circumstances beyond anyone's control, not by any act of restraint by the defendant.
Yes. Mr. Rodriguez's case is here today as the motion for required finding should have been granted specifically in regards to the kidnapping charge in this case.
So could I just ask a housekeeping question that's actually quite important, which is, are you challenging?
All 3 of them, Your Honor, and
Okay.
I apologize if I did not make that as clear as it should have been in my writings. As ultimately the argument would apply the same as to all individuals that were involved in regards to this. Because, as Your Honors are aware, for kidnapping, it would require the intent to kind of confine the victim. And there was no intent here in that regards. Now, obviously, there were criminal activities that took place, as I'm not stating otherwise. There was certainly an intent to attack these people, which did unfortunately take place. But an attack alone, obviously, does not automatically mean kidnapping. The level in which the victims were constrained wasn't because of Mr. Del Valle Rodriguez, it was because of, well, bad luck, essentially. It was the car getting stuck in the mud, which no one actually did. It's not as though that was set up or anything.
I think, well, there are many things the Commonwealth did argue. I guess one argument would be that once you realize you're stuck in the mud, you'll get out of the vehicle and try to push it out of the mud, and that here they couldn't get out of the vehicle when they might have otherwise wanted to. So what do you say to that?
Well, I mean, getting out of the vehicle resulted in, obviously getting out of the vehicle leads to an interaction with the individuals here, the defendant and otherwise. So that did lead to the interaction which happened, which led to the other criminal actions, which is not an issue, which is not being challenged today. So that certainly happened. It's not that they could not get out of the vehicle. No one was, in fact, quite the opposite. It's not that they were preventing them from getting out of the vehicle, quite the opposite. The defendant and other individuals wanted them to get out of the vehicle. So there was nothing actually preventing them in regards to confining them getting out of the
Defense attorney Philip Weber argues that his client's kidnapping conviction should be overturned because the defendant lacked any intent to confine the victims. The victims were trapped in their vehicle only because it was stuck in mud, a circumstance caused by weather, not by any act of the defendant. Under Massachusetts General Laws, Chapter 265, Section 26, kidnapping requires proof that the defendant knowingly confined or imprisoned another person against their will. The Massachusetts Supreme Judicial Court has long distinguished between kidnapping and other violent crimes based on the specific element of unlawful restraint. In Commonwealth v. Saylor, decided by the Appeals Court in 2016, the court clarified that while general intent, meaning the intent to do the physical act of confinement, suffices for kidnapping, the prosecution must still prove that the defendant actually confined the victim through direct action, not merely that the victim felt unable to leave due to fear. Weber's argument hinges on a critical distinction. The victims were not confined by anything the defendant did, but rather by environmental circumstances. The car stuck in mud created the physical barrier, not the defendant's conduct. Weber analogizes the situation to someone breaking down a door to attack a victim. Gaining access to commit assault is not the same as kidnapping. The defendant's alleged intent was to attack, not to imprison. In fact, Weber emphasizes that the defendant wanted the victims to exit the vehicle, the exact opposite of confinement. This case illustrates how courts must carefully parse the elements of kidnapping to prevent it from swallowing every violent crime where a victim feels trapped. If fear alone, or circumstances beyond a defendant's control, could sustain a kidnapping conviction, then prosecutors could routinely add kidnapping charges to simple assault cases, dramatically increasing sentencing exposure without corresponding culpability. The line between assault and kidnapping protects defendants from disproportionate punishment and ensures that the stigma of kidnapping attaches only to those who actually engage in unlawful restraint.
Well, the defendant and the other men were beating on the, and so even though they wanted them out.
I would argue I'm sure the victims felt fear. They probably were scared in that situation and weren't sure what would be the way to go and where they would want to go. But feeling fear and maybe wanting to try to escape from a perpetrator in and of itself, I would say, does not amount to kidnapping. Just because a person wants to go, the idea that they would want to run off in some direction, but they have these people who are trying to physically harm them, that in of itself, I would argue, is not amounting to kidnapping. I mean, they were threatening them. If there had been a charge for threatening, I certainly would have been a possible charge. Because again, it's not a quick statement that there was no criminal activity. Obviously, in a situation like this, and to the facts as they amounted, it would be, I think, essentially impossible to argue there were no criminal activity. But the difference between whether there was criminal activity and the type of criminal activity is the question here today. And I would argue that what happened didn't amount to kidnapping, because it's to constrain someone just through the idea of, well, I'm scared if I get out, there will be a fight, is, I would argue, not in and of itself kidnapping, especially since, the idea that they would, because as Your Honor stated, if no one else had been there, if they had just been caught in the mud without anything else, their action would have been to get out of the car and try to free themselves from the mud. That's what the defendant wanted for them to get out of the car. Because that's the thing, the defendant would have wanted them to get out of the car. So the idea that, well, they can't get out of the car because the defendant and others were there, I would argue goes counter to what the defendant's intent was. Because the defendant's intent wasn't to keep them in the car. Literally the opposite. Wanted them out of the car. The yelling is about wanting them out of the car. So the thing that they would...
The Commonwealth, though, is going to focus on the restraint of movement, and that he was restrained from moving out of the car to free themselves from the mud.
Well, they were not actually, and I would argue that they weren't restrained from getting out of the car. They were, I'm sure, scared to get out of the car. I mean, and I would argue that in any circumstance in which there is violence, in any circumstance in which there's, criminal activity of a violent sort, there's going to be, a level of fear and concern from a victim in terms of, what will happen if I do a certain action. But just the sheer idea of fear alone would not constitute kidnapping, especially when the fear here is to do the thing that the defendant wants them to do. Because again, it's everything they want to do is the defendant didn't want this individual.
The judge presses Weber on whether the victims were effectively restrained by the combination of the stuck vehicle and the violent attack, even if the defendant wanted them to exit. Weber maintains that fear of violence is inherent in any assault and cannot transform assault into kidnapping. The Massachusetts Supreme Judicial Court addressed this precise issue in Commonwealth v. Morrison, 418 Mass. 1001, 1994, where the court emphasized that kidnapping requires more than the incidental restraint that accompanies other crimes. The incidental restraint doctrine prevents prosecutors from piling kidnapping charges onto underlying felonies when the confinement is merely a means to commit another crime or an inevitable byproduct of it. Similarly, in Commonwealth v. Rivera, 397 Mass. 244, 1986, the court held that where the restraint is brief and inherent in the commission of another crime, it does not constitute kidnapping separate from that offense. Weber deploys the incidental restraint doctrine directly. The victim's hesitation to exit was not independent confinement, but rather the natural fear any assault victim experiences. He argues that accepting the Commonwealth's theory would mean every assault becomes kidnapping because victims typically fear moving during an attack. The fight or flight response Weber references is biologically universal. Victims of violence always face the dilemma of whether to flee or remain. Transforming this universal feature of violent crime into kidnapping would obliterate the statutory distinction between these offenses. The incidental restraint doctrine preserves the integrity of criminal charging by ensuring that defendants face punishment proportionate to their actual conduct. Without this limitation, prosecutors wielding kidnapping charges, which carry substantially enhanced penalties, could coerce plea agreements on lesser charges even when the underlying conduct was simple assault. This prosecutorial leverage threatens fair trial rights and undermines the legislative intent in distinguishing degrees of criminal conduct.
These individuals
Do you agree with the Commonwealth that specific intent isn't required?
I would argue, the problem here I would argue is that there would need to be some kind of intent to confine the victim. And that intent, I would argue, is not present here. So the idea of
But that is specific intent. You're saying there has to be.
well, it's not so much as that Your Honor's reading the prongs. Obviously, Your Honor's, quite aware of the prongs of the, actually, it's more so that the intent of the defendant here wasn't about confinement in any way. The intent here was to attack these people. That's the intent, is to attack these people. And in the same way that if someone is behind a closed door and someone tries to break down a door to get to somebody, if a defendant breaks down a door to try to get somebody so they can attack them, they didn't kidnap them by breaking down a door, even though the intent there is to gain access to the person. Because that's the thing, the ultimate intent here was to attack them. You have to gain access to them. You can't attack someone if you're not within physical reach of them, of course. So the intent here was to gain that physical access to them so that they could attack them, which certainly leads us to all the other offenses.
A general intent analysis, and so you're trying, I think it seems like you're just kind of trying to sort of say, though there's more here, you're actually, I guess, is there a different way to look at this issue than is there some other way to look at this from a general intent perspective that supports your argument?
Well, even from a general intent perspective, I would argue that even if we're not talking in regards to confinement, there would need to be some kind of general intent to kind of limit the movement of the victim involved. And ultimately, the intent we have here is just to harm. It's an intent to attack, to harm, but there was never any kind of intent to limit their movement in any kind of way. The intent here was, again, just simply to gain access to them. That's why I made the analogy to breaking down a door, or even if it was, even if the intent was, even if someone was running after someone. I mean, if two people were in an open field and a defendant was running after someone to try to attack them, then I don't think we would be reasonable in saying, well, this victim wouldn't feel comfortable staying still, because if they just stayed still, they would, because of what was happening. I mean, any kind of action in which one person attacks another is going to cause a victim to feel some type of feelings in regards to whether they can stay still or try to flee. I mean, that's fight or flight is essentially, and in this regard, the flight part is always something that comes into play when you have one person attacking another. So there's always an element in which a victim will feel like, okay, can I stay still or do I need to go somewhere else? That's true in any type of violent act.
Not every type of violent act has the confinement aspect too, right? And here, unfortunately for your client, there was like the confinement in the truck thing that is a wrinkle to. I totally see your point.
Well, the period, and I would argue the period that they were confined within the truck, and again, as I stated, the car being stuck in the mud, bad luck, not about any person, just rain. It rained, it was muddy, the car got stuck. No one did that, so it's not as though they were stuck inside of a truck because of something the defendant did. If the mud's not there, they hit the gas, they drive off, the end. We only have that because of that. And then at that point, nothing that the defendant did actually forced them to stay inside of the truck. I mean, staying inside of the truck, maybe someone breaks the window and gets in. I mean, we didn't get to that point, so we don't know. But none of the defendant's actions would have actually kept them inside of the vehicle. In fact, it seems, as Your Honor was pointing out, they probably at that moment, well, whether they would have preferred to stay inside the vehicle or not, we can't say for certain. We didn't get any direct testimony about what they wanted in that moment, but the defendant certainly wasn't keeping them inside the vehicle. The defendant wanted them to get out of the vehicle, and that's about gaining access to a victim. And if gaining access to a victim, actions taken to gain access to a victim, were to constitute kidnapping, then I would argue that just about any kind of criminal activity in which a person is gaining access to a victim would suddenly constitute kidnapping. Because if we'd applied it to this case, and kind of the crux of my argument here is that if an act about gaining access to someone means that it's kidnapping, when does it not apply? The actions here were to gain access to the victims. That's what the idea was. That's what the actions of the defendant were. And certainly, those actions constitute types of criminal activity. It's not as though what the defendant did is just allowable. There's certainly no argument in regards to that. Even if Your Honors were to agree with my argument, there are still criminal convictions that would stand. So this is not about everything going away. It's specifically in regards to the kidnapping, because ultimately the actions of the defendant and the others involved were to gain access to the victim for the purposes, certainly, of attacking them. That was why they wanted to gain access to them. So they didn't perform any actions that kept them in the car by any means. And even in regards to them getting out, I mean, they were attacking the car to get to these people. By doing so, it leads to the charge we have, but I would argue that the kidnapping charge was a step too far, essentially. That was the charge and resulting fiction that should not have been in place here, because whether we look at it in regards to a general intent, specific intent, the intent really was to attack them. There was no intent to do anything beyond that.
So the Commonwealth argues that your reliance on Commonwealth versus Morrison is misplaced because in that case, the person was charged as an accessory before the fact. What do you say to that?
And I apologize that I don't have that site right in front of me in regards to that, but regardless, I would argue that the arguments that I make, whether or not you charge someone as an accessory or as a primary, ultimately that is not what this case was hinging upon. This case, I would argue, is hinging upon, at least in arguments about what the idea was, what the intent of the defendant was. So I would argue that that distinction would not be controlling in this case in regards to the ultimate outcome. And unless there are any further questions, I would rest on my brief.
Thank you very much. We'll hear from the
The judge challenges Weber on whether he is implicitly requiring specific intent for kidnapping, which would contradict established precedent. Weber pivots, arguing that even under general intent principles, the defendant's purpose was access for assault, not limitation of movement. Massachusetts courts have consistently held that kidnapping is a general intent crime, meaning the prosecution need only prove that the defendant intended to do the physical act of confinement, not that they had any particular ulterior purpose. In Commonwealth v. Saylor, 90 Mass. App. CT. 623, 2016, the appeals court explicitly rejected a specific intent requirement, holding that the Commonwealth did not need to prove that the defendant harbored a specific intent to confine a victim. Proof of general intent to commit the act of confinement sufficed. However, general intent still requires proof of intent to commit the actus reus, the physical confinement itself. Weber's strategic concession that general intent applies allows him to focus on the critical evidentiary gap. Even assuming general intent suffices, there was no intent here to limit movement. The defendant's goal was proximity for assault, not restraint. His analogies, breaking down doors, chasing across open fields, demonstrate that gaining access to commit violence is categorically different from imprisoning someone. The victim's subjective feeling of being trapped, Weber argues, stems from the assault itself, not from any independent act of confinement. This distinction between general intent to confine and intent to assault preserves the constitutional requirement that criminal liability attach only to voluntary acts with the requisite mental state. Even under general intent doctrine, prosecutors cannot simply presume intent to confine from the presence of violence. They must prove that the defendant's conduct was directed toward restraint, not merely that restraint was a side effect of violent confrontation.
Good morning, Your Honors. May it please the Court. Sarah Swan for the Commonwealth. First of all, there is no question that only general intent is required. I would agree with you, Justice Toon, that the defendant would not prevail on a specific intent belief. With general intent, I believe Commonwealth v. Saylor sort of explains what's going on, what's required. This court explained that the Commonwealth did not need to prove that the defendant harbored a specific intent to confine a victim. Merely the fact that the defendant had confined the victim was sufficient. That is all that is required for general intent.
Could you just give me a little bit more? What is the general intent?
For general intent, it is just that you would intend to conduct the criminal conduct. So here that is the participating in the aggressive attack on the truck. That alone is sufficient. It's a mob attack to prevent the people inside that vehicle from moving, and that therefore is connected to the confinement and their restraint of their movement.
Well, but let's make it a simpler case that they jumped into a vehicle that had no engine in it, so that everybody knew there was no chance the vehicle was going to move. And it is as your opponent argues, they wanted him out of the vehicle. They didn't want him in the vehicle. They wanted to beat him up or shoot him. So where's the intent to do anything to confine him?
the intent to want them to come out for another purpose is really irrelevant to the analysis. General intent just requires that the defendant do the conduct, which is to effectively restrain the victim's movements. So,
But weren't their movements already constrained while the defendant was still walking towards the situation?
so as the defendant's walking toward the situation, his close friend, who he had been in contact with while at the party, was there already, and he was going to join them, and in fact did join them in banging on that truck, and not allowing the people to get out or at the time or at that moment or leave. And then at some point, the restraint sort of transitions to get out or we'll start shooting. And they used the co-defendant who used that language said we, which the Commonwealth argues includes this defendant, which then in fact happened. The defendant did utilize the 9mm gun that he was in possession of and shot the victim.
Right, so I am trying to
Judge Henry pressed the prosecutor on the outer boundaries of kidnapping law, testing whether brief restraints, victim self-confinement, and incidental confinement during other crimes could satisfy the statutory elements. The exchange revealed tension between Massachusetts's broad judicial interpretation of confinement and intuitive common-sense understandings of what kidnapping should require. Under Massachusetts General Laws, Chapter 265, Section 26, kidnapping requires proof that a defendant forcibly or secretly confines or imprisons another person within this Commonwealth against his will. In Commonwealth v. Lent 423 Mass. 86, 1996, the Supreme Judicial Court held that even brief restraint satisfies the confinement element where the victim's movement is substantially restricted by force or threat. The court has consistently rejected any durational requirement, emphasizing in Commonwealth v. Rivera 397 Mass. 244, 1986, that the quality of restraint matters more than its quantity. However, the merger doctrine recognized in Commonwealth v. Wilson 389 Mass. 115, 1983, prevents double punishment where confinement is merely incidental to another felony and does not pose independent dangers beyond those inherent in the underlying crime. The prosecutor's reliance on Commonwealth v. Parker, an unpublished decision, and Commonwealth v. Lent illustrates how Massachusetts courts have expanded kidnapping liability to encompass situations where victims are effectively trapped rather than affirmatively seized. Judge Henry's sports celebration hypothetical exposed a critical limiting principle. The absence of threatened force distinguishes revelry from kidnapping, even where movement is physically obstructed. The court's probing questions about the panic room scenario tested whether victim self-confinement triggered by defendant conduct satisfies the against his will requirement, particularly where the defendant never affirmatively directed the victim's movement. This exchange illuminates the constitutional stakes of statutory interpretation in criminal law. When courts adopt expansive readings of crimes like kidnapping, traditionally understood as involving asportation or prolonged detention, they risk criminalizing conduct that defendants could not reasonably have understood as felonious, potentially violating due process notice requirements under the 14th Amendment. The merger doctrine serves as a crucial safeguard against prosecutorial overreach, ensuring that incidental restraints during robberies or assaults do not automatically trigger kidnapping liability with its severe sentencing consequences. The appellate panel took the matter under advisement following oral argument. No immediate ruling issued from the bench. The case presents certified questions regarding whether the evidence was sufficient to support kidnapping convictions under Massachusetts's general intent framework, and whether the jury instructions properly distinguished between confinement as a means to an assault versus confinement as an independent criminal objective. The defendant remains in custody pending resolution, with the appeal challenging both the sufficiency of evidence and the legal standard applied at trial. The court's decision, when issued, will govern how Massachusetts trial courts instruct juries in kidnapping cases where confinement is brief, incidental to another crime, or accomplished through threat rather than physical barrier. This case illustrates the fundamental tension between legislative text and judicial interpretation in criminal law, specifically how courts must balance public safety against the constitutional requirement that criminal statutes provide fair notice of prohibited conduct. When kidnapping statutes written to address traditional abductions are applied to brief restraints during street violence, courts risk either diluting the seriousness of the charge or criminalizing conduct that falls within the penumbra of uncertainty, raising concerns under the void for vagueness doctrine. The proper scope of kidnapping law matters beyond this defendant. It shapes charging decisions, plea negotiations, and sentencing outcomes across thousands of cases, making judicial clarity essential to consistent, predictable justice. If you found this deep dive into Massachusetts kidnapping law valuable, explore our analysis of other appellate arguments testing the boundaries of criminal intent. Subscribe for weekly breakdowns of real courtroom proceedings that make complex legal doctrine accessible. Thank you for engaging with the mechanics of justice.